What bugs me so much about the election stuff is that Todd Blanche is telegraphing to the public that investigations work in the opposite order they actually do. They're trying to seize evidence first, and only afterward, apparently, are they going to construct a legal theory about some kind of fraud. That is what we would politely call a fishing expedition. And what we would probably call in private something much less polite. Good evening, everyone. It is 5 o'clock in New York. That warning from a former senior FBI official is important because it captures, in one sentence, the central problem with what is unfolding inside the Justice Department right now. In a functioning justice system, prosecutors begin with facts. They establish a predicate. They identify evidence. They develop a legal theory. They test that theory against the law. And only then do they use the extraordinary power of the federal government to subpoena records, seize devices, pressure witnesses, or bring charges. What we are seeing now, according to whistleblowers, court filings, public reporting, and former Justice Department officials, is something very different. The target appears to come first. The legal theory comes later. And the evidence, if it exists at all, is treated less like the foundation of a case and more like something to be searched for after the political decision has already been made. That is the story at the center of new reporting on the Trump administration's pressure campaign against elite universities. The stated justification was campus antisemitism, a serious and real issue that deserves serious, fact-based investigation. But according to a whistleblower complaint filed on behalf of a veteran civil rights attorney and colleagues inside the government, the investigations into several major universities were not conducted as neutral inquiries designed to follow the facts wherever they led. They were allegedly designed to reach a predetermined result. The complaint accuses administration officials of using allegations of antisemitism as a pretext to pressure Brown, Columbia, Harvard, and other institutions by threatening or cutting federal grants. And the core allegation is not subtle. According to the whistleblower account, investigators raised concerns that they did not have enough evidence to conclude that the universities had violated the law. When they raised those concerns, they were allegedly ignored, sidelined, or reprimanded. That is not a small internal disagreement over tactics. That is the difference between law enforcement and political enforcement. And it matters because the Justice Department is not just another agency. It is the arm of the federal government with the power to destroy reputations, freeze funding, force settlements, and put people in prison. When that power is used according to facts and law, it is the justice system. When that power is used according to political preference, it becomes something else entirely. According to the complaint, lawyers inside the department objected to the absence of a factual basis. They said the evidence did not support the conclusion that the schools had broken the law. They warned that the cases were moving forward anyway. And at least one official eventually left the department because she believed she was being asked to participate in investigations that were politically motivated, unsupported by facts, and contrary to law. The Justice Department denies wrongdoing. Officials say the investigations are legitimate and that they stand behind them. But here is the problem. This whistleblower account does not exist in isolation. It fits into a pattern. We have now seen multiple examples of the same basic architecture. A political grievance is identified, a target is selected, federal power is brought to bear, and the legal justification is constructed after the fact. That is what former FBI officials mean when they talk about reverse engineering justice. And that is what alarms career prosecutors, investigators, judges, and national security officials who have spent their lives inside institutions built on the idea that facts come before conclusions. Congressman Jamie Raskin, the ranking member of the House Judiciary Committee, responded to the whistleblower complaint by saying, in essence, that anti-Semitism at universities is real and must be confronted, but that this investigation appears to have been fake in the sense that the outcome was allegedly decided before the evidence was gathered. That distinction is essential, because one of the most dangerous things a government can do is take a real social problem and weaponize it as a political tool. Campus anti-Semitism is real. Political abuse of enforcement power can also be real. And a serious government has to be able to confront the first without committing the second. The reporting suggests that investigators inside the Justice Department were saying exactly that. They were not saying universities should be immune from scrutiny. They were not saying antisemitism should be ignored. They were saying the government needs evidence before it punishes institutions, freezes grants, or forces settlements. That is not radical. That is the rule of law. And yet, according to the whistleblower, that principle was treated as an obstacle. Now joining us in this analysis are the kinds of voices who understand why this matters: former prosecutors, national security professionals, investigative reporters, and people who know what the Justice Department is supposed to look like when it is functioning properly. The first point they keep making is about something called the duty of candor. Prosecutors do not just have a duty to win. They have a duty to the court. They have a duty to the law. They have a duty to disclose material facts, including facts that may undermine their own case. If the government knows its evidence is weak, contradictory, or incomplete, it cannot simply bury that reality and continue applying pressure as if the case is solid. That is not how federal prosecution is supposed to work. And yet that is exactly what insiders are now alleging, that government lawyers knew there were factual problems, raised those problems, and were overruled by officials determined to push forward anyway. That is why this whistleblower report matters. It is not just another political complaint. It is an account from inside the machinery. And that is rare. People inside the Justice Department do not casually become whistleblowers. They know the risks. They know the professional consequences. They know they may be attacked, discredited, or isolated. So when someone with direct knowledge steps forward and says the facts did not support the enforcement action, that deserves serious scrutiny. But this story becomes even bigger when you place it next to the Justice Department's own recent court filings. Because in another case, involving former FBI Director James Comey, federal prosecutors have made an argument that is astonishing in both its bluntness and its implications. They argue that the independence of the Justice Department from the White House is, historically speaking, a myth. Read that again. A myth. For decades after Watergate, the norm has been that the Justice Department must exercise criminal enforcement power independently from the personal political interests of the president. That does not mean the department is outside the executive branch. It does not mean the Attorney General is not appointed by the president. It means that criminal prosecution is not supposed to function as a personal instrument of presidential reward and punishment. That norm exists for a reason. It exists because the power to prosecute is the power to ruin lives. And if a president can direct that power against enemies, critics, universities, law firms, journalists, former officials, or political opponents, then the line between democracy and authoritarianism begins to dissolve. The Justice Department's new position appears to be that if the president directs subordinates to use executive power, that is simply how the constitutional system works. But that argument skips this central question. Can a president direct the criminal justice system toward personal retaliation? Can federal law enforcement be used to punish critics? Can investigations begin with a target rather than a crime? Can prosecutors pursue cases they know are unsupported by evidence because political leadership wants pressure applied? Those are not academic questions anymore. They are active questions in federal court. And judges are beginning to confront them. We have already seen federal judges question the administration's legal theories in several high-profile cases. We have seen judges raise concerns about due process. We have seen judges reject arguments that the executive branch can simply act first and justify later. And now we are seeing the Justice Department itself put into writing a theory of executive power that critics say would remove the guardrails built after some of the darkest abuses in modern American political history. This is why the phrase, independence of the Justice Department, matters. It is not a slogan. It is a safety mechanism. It is one of the things that prevents the legal system from becoming a political weapon. And if that safety mechanism is declared a myth, then the entire relationship between the citizen and the state changes. Because the question becomes not whether you broke the law. The question becomes whether someone in power wants you investigated. That is the danger. And it extends far beyond universities or former FBI directors. It can reach law firms. It can reach nonprofits. It can reach journalists. It can reach state officials. It can reach local election workers. It can reach anyone who becomes inconvenient to power. That is why former intelligence and national security officials are sounding alarms. They understand that institutions are not self-executing. They depend on people inside them refusing unlawful orders, documenting misconduct, telling courts the truth, and walking away when they are asked to cross lines they cannot ethically cross. The phrase you hear again and again from people inside these systems is simple: hold the line. But the line only holds if there are consequences when it is crossed. And that is the question hanging over all of this. When will there be accountability? When prosecutors are allegedly told to pursue cases without a factual basis, who answers for that? When federal funding is frozen as leverage to force settlements, who reviews whether the leverage was lawful? When the Justice Department tells a court that its independence is a myth, who protects the public from what that theory would unleash? Those questions are now central to the health of American democracy. And after the break, this same theme, institutions under pressure, power operating without accountability, and the human cost of political decision-making, takes us to the military. Because after months at sea, the USS Lincoln may finally be heading home, but for thousands of sailors in the broader carrier group, there may still be no clear end in sight. The Lincoln's extended deployment has become a symbol of something much larger than one ship. It is a symbol of what happens when strategy is unclear, planning is inadequate, and the people asked to carry out national policy are treated like movable pieces on a board rather than human beings. According to reporting from inside the deployment, sailors have endured shortages of food and basic supplies, plumbing failures, broken equipment, exhaustion, and collapsing morale. One sailor described the atmosphere as people simply holding on because they have no other choice. That should shock every American. Not because military service is easy. It is not. Not because deployments are supposed to be comfortable. They are not. But because the men and women who serve are owed competent leadership, clear objectives, and a chain of command capable of planning beyond the next headline. The concern raised by former military officials is that this is not just a morale issue. It is a readiness issue. When ships are kept at sea too long, equipment breaks. When sailors are pushed past endurance, mistakes happen. When maintenance windows are missed, future deployments become more dangerous. And when adversaries like China, Russia, Iran, and North Korea watch the United States struggle to rotate assets, sustain forces, and explain the purpose of an ongoing mission, they take notes. That is the geopolitical consequence. Military power is not just weapons and ships. It is logistics. It is maintenance. It is morale. It is strategy. And if any one of those components fails, the entire posture weakens. That is why the reporting on the Lincoln matters. It is not simply a story about one carrier. It is a story about whether the United States can sustain military commitments without burning through the people and platforms required to maintain them. And once again, the human consequences are the clearest signal that something in the system is not working. Families are waiting. Sailors are exhausted. Commanders are improvising. And Congress, which is supposed to exercise oversight over war powers, deployments, readiness, and military conditions, is too often absent from the field. That brings us back to the central theme of the hour. Institutions do not collapse all at once. They are hollowed out by pressure, silence, fear, and the normalization of behavior that would once have been unthinkable, which brings us to the Supreme Court. A new watchdog report has identified hundreds of gifts received by Supreme Court justices over the course of 2 decades, totaling millions of dollars in estimated value. Flights, luxury travel, tickets, jewelry, honorary items, expensive keepsakes, and private hospitality, all cataloged in disclosures, records, and ethics reports. The justice receiving the most attention is Clarence Thomas, whose gift history has become central to a broader crisis of confidence in the court. The issue is not whether every gift is illegal. The issue is whether the highest court in the country can maintain public legitimacy while its members accept expensive benefits from wealthy individuals, some of whom may have interests connected to the legal and political world the court shapes. The Supreme Court now faces historically low approval numbers. And that decline is not just about ideology. It is about trust. Americans may disagree with court decisions. That has always been true. But when they begin to believe the court is insulated from accountability, indifferent to ethics, and unavailable to ordinary standards of transparency, the damage becomes deeper. The court has adopted a code of conduct. But without an enforcement mechanism, critics argue that the code is more symbolic than structural. And symbolism is not enough when public confidence is already collapsing. So tonight, across all three stories, the Justice Department, the military, and the Supreme Court, the question is the same. Who holds power accountable? If prosecutors can reverse engineer investigations, who stops them? If the executive branch can treat Justice Department independence as a myth, who draws the line? If sailors are kept at sea under brutal conditions with no clear strategic endpoint, who demands answers? If Supreme Court justices accept expensive gifts under weak disclosure and enforcement rules, who protects the legitimacy of the court? These are not separate scandals. They are symptoms of the same democratic stress test. The pressure is on the guardrails. The question is whether the guardrails still hold. And the most dangerous part is not that officials are saying the quiet parts out loud. It is that they are now putting them in writing, filing them in court, defending them on television, and daring the rest of the system to stop them.